Is this emergency constitutional? In my opinion, no. There are four main points for us to consider. The first question is, when the cabinet recommended an emergency, was it a valid cabinet under Article 43, Clause 1, Paragraph A? Did a constitutionally legitimate cabinet exist? Can the king make his own decision to declare an emergency? The answer is no. The decision to declare or proclaim an emergency must be recommended or advised by the cabinet headed by the Prime Minister. That is in Article 40 of the Constitution. But to advise His Majesty the King to declare an emergency, there must be a valid cabinet in existence in the first place. So, is there a valid cabinet? There could have been, had a majority of the MPs in Parliament supported the Prime Minister. That's because the Prime Minister must be someone who commands the confidence of the majority of the members of Parliament. Did he have that confidence? In my view, he did not. What is the meaning of the word majority under Article 43? A number of decided cases have held that majority means 50% of the MPs plus one. In our Parliament, the majority of 222 is 111 plus 1, which is 112. On two important occasions, the government did not have the majority of 112 votes. The first is when government MPs tried to remove the Speaker on July the 13th, 2020. The second time the government was tested was on December the 15th, 2020, when the budget was allegedly passed. In my view, legally, it was not. On both occasions, the government had only 111 votes. Now that fell below the constitutional majority of 112. There are several cases on this. I cite them here. And this means that the proclamation was recommended or advised to His Majesty the King by a cabinet that did not have a constitutional legitimacy under Article 43, Clause 2, Paragraph A. This lack of legitimacy is demonstrated in several ways. For one, the Emergency Regulations 2021 says it is superior to any other written law, which means the Constitution. Two, the compulsory parliamentary approval procedure in Article 150, Clause 3 has been sidestepped. Three, Parliament sittings have been indefinitely postponed or suspended. 4. Constitutional guarantees of elections have been deleted. 5. Essential parts of the Constitution have been amended or deleted. Since the cabinet is non-existent, in my view, advising the king to call for an emergency is outside the law. If I am wrong in this view, there are several other points that make this emergency and the regulations unconstitutional anyway. For one, the emergency regulations destroy the fabric of the Constitution in 5 different ways. The regulations say that all the rules or regulations are superior to any other written law. Now this cannot be right, because the only body that can make law is Parliament, and that is stated in Article 44. There is an exception. Under 150, one can make emergency regulation. Second, Article 4 of the Federal Constitution states that it is the Constitution that is the supreme law of the Federation. These regulations, which are said to have the same strength as an Act of Parliament, are subordinate to the Constitution. If the Constitution says it is superior law, how can a regulation claim itself to be superior to the Constitution, particularly when the lawmaking body Parliament is absent or on leave? So therefore the regulations are unconstitutional. The regulation uses a phrase, written law. The Constitution defines written law as including constitutional law. So these regulations amend the basic foundations of the Federal Constitution. Now that's unconstitutional. An Indian Supreme Court case called Kesavananda Bharati says so. That is a case that has been celebrated and accepted all over the Commonwealth, including the Malaysian courts. The next point I want to consider is the laying procedure before Parliament. That is required under Article 150, Clause 3. The emergency regulations put Parliament on leave, thereby killing the constitutional prerequisite. The regulations attack the Constitution by postponing Parliament. Under Article 150, Clause 3, both the Royal Proclamation as well as the emergency regulations must be laid before Parliament. Parliament can either endorse, vary, or reject both the proclamation and the regulations on behalf of the people. Now, by postponing Parliament or suspending it, the Cabinet has killed this essential constitutional procedure. It has therefore sidestepped the laying before Parliament procedure. The Federal Court, in the case of Lim Woon Chong and another versus PP in 1979, said if there was no laying procedure carried out, then there is no legal power in the proclamation. The 1979 Privy Council case of Teh Cheng Po decided that His Majesty the King can only exercise powers that the Constitution gives him. That principle was confirmed by our Federal Court in the case of Lim Woon Chong. Without the laying procedure before Parliament, the emergency proclamation as well as the emergency regulations cannot be valid. The Cabinet cannot go on with the emergency. That defeats the Constitution and destroys the rights of the people and the MPs to object to, first, the proclamation, and second, the regulations. The third point is the refusal to call Parliament to an early session. Parliament regulates its own procedure. If a real emergency exists, parliamentary standing orders allow the Cabinet to call for an urgent early sitting of Parliament. What is to stop 200 MPs calling for an early sitting? But the Cabinet hasn't. What does this tell us? It tells us that the Cabinet says there is an emergency but behaves as if there is no emergency. Surely the Cabinet could have called for a parliamentary session by way of a Zoom meeting. Every other country is doing it. Why not us? This reluctance is odd. Do you not think so? Now imagine this. Suppose country X is attacking Malaysia. As a nation, we need to defend ourselves. Obviously, we cannot wait for Parliament to return from its recess. But suppose after a short time, perhaps a week of defending ourselves, the Cabinet should report to Parliament because the Cabinet is the servant of Parliament for more money and budgets for troops and armament. If the Cabinet does not, any money it spends is not authorized. Now the government during emergency can spend money without asking for Parliament's permission. Because Parliament has been suspended, no laying procedure can take place. The procedure under Article 150, Clause 3 cannot go on. That cannot be right. That's unconstitutional. But if the emergency regulations are passed, some clauses in the Constitution say we cannot question any decision that the Cabinet makes. Is that right? If that's not unconstitutional, what is? The next point is, the emergency regulations destroy the right to election every 5 years. Now, the people have the right to change the government every 5 years. The Constitution guarantees it. The current Parliament sat for the first time on the 16th of July 2018, if you recall. Now, that is to last until the 16th of July 2023. However, the regulation deletes Article 55, which requires elections every 5 years. This means the emergency can go on for longer than 5 years and far beyond July of 2023. If the government were to change now the word deleted to suspended in those regulations, even then the regulations are void. So these regulations seem to demonstrate that the Cabinet's intention is not pointed in the right direction. It also shows that the Cabinet behaves as if it is a legitimate Cabinet, when in fact, in my respectful view, it's not. So what's the solution? There are several solutions. If the Prime Minister and the Cabinet realize they have no parliamentary majority, lacking constitutional imperative, the Prime Minister and the entire Cabinet should resign. Second, if His Majesty realizes there is no majority supporting the Prime Minister, may remove the Prime Minister and thereby the Cabinet. In at least 2 cases involving Chief Ministers of Perak and Sabah respectively, this is what happened. And the Federal Court has upheld the principle. Third, anyone affected by the emergency can apply to the court for a declaration that there is either no emergency or if there is one, the regulations are invalid. In a 2019 Supreme Court case in the United Kingdom called Re Miller, the Cabinet's decision to suspend Parliament was challenged and the court held that the decision must be rational. If not, the court can order Parliament to reconvene. And that is what should happen in this country. Anyway, all this is my opinion. Thank you very much for watching. Goodbye.